Hey everyone, James Willis here from Daly Black. Today we're going to talk about the issue of appraisal and some of the pitfalls and concerns that often get overlooked with appraisal. Now we all know that appraisal is often a quick, efficient, and inexpensive means of resolving a dispute between the policyholder and the insurance company over the amount of loss. But that's the only dispute that can be resolved by appraisal. What is the amount of loss? It won't resolve issues about coverage or the scope of the appraisal. And it won't help the homeowner in situations where they can't afford the appraisal process. So I want to talk to you about these pitfalls, and I want you to consider that maybe sometimes appraisal is not always the best means of resolving an issue for a policyholder. So one issue we often see is the issue of coverage. The classic example is a claim goes to appraisal, the appraisal award comes down, and the insurance company will not pay it because they think that the damage is just cosmetic. It falls under the cosmetic damage exclusion. Now when that happens, the policyholder is right back to square one. They've gone through appraisal, they've paid for an umpire and an appraiser, but they still haven't gotten their claim paid. In that situation, it might be best to talk to an attorney. Going down to the courthouse might be the only means of resolving that dispute. The other situation that we often see is over the scope of the appraisal. The homeowner might think that the appraisal is supposed to include the windows, the gutters, the AC units, and the roof. But the insurance company might say, no, the appraisal is only supposed to be for one slope of the roof. If that's a situation, appraisal is never going to resolve the dispute, and it might be best to talk to an attorney. One other thing we see is with the cost of appraisal. The ideal situation for a policyholder is that through this process they are made whole or they're almost made whole. They can live with the outcome. But I have many clients who can't live with the outcome of appraisal, even when the appraisal award gives them the full amount for their loss. A classic example is with the elderly and the retired. Perhaps an appraisal award comes down for $9,000 on a 3,000 square foot roof. After subtraction of the deductible, the insured is down to $7,000. And why that might be fair under the policy, the part that's not fair to the homeowner is that they had to drop another $2,000 for the umpire and the appraiser just to get the claim paid right to begin with. What happens there is that the widower or the pensioner is left with $5,000 and not enough money to put a new roof over their head. That might be a situation where appraisal doesn't help somebody out. We'd love to hear from you about these issues at Daly Black. And one thing we're trying to educate everybody about out there is that in Texas, the landscape has changed regarding appraisal. In June of 2019, the Texas Supreme Court issued an opinion regarding appraisal and what happens to a claim after appraisal. It used to be that insurance companies loved invoking appraisal, especially after they got sued down at the courthouse, because they could use it as an escape hatch to get away from any delay penalties or bad faith damages. In other words, 2 years, 3 years down the road, they could walk away from a claim owing nothing more than what they were supposed to have paid to begin with. The Texas Supreme Court said that practice is done. If an insurance company has delayed payment of a claim to the policyholder, when they were liable on that claim, they can still be held liable under the Texas Prompt Payment of Claims Act. If you have any questions regarding this, we'd love to educate you about that here at Daly Black. Give us a call.